Assalamualaikum warahmatullahi wabarakatuh. My name is Alia Atika Najwa and I am the first presenter. I'm going to be addressing the first issue. So the first issue is whether Nadira, Azlan and Faizal had committed a breach of liability in administrating the trust. So under the Trustees Act 1949, trustees are under strict duties to act honestly and for the benefit of the beneficiaries under Section 5 to not profit from the trust, keep trust assets separate from personal property, also keep proper accounts and act prudently in managing the trust. As for Nadira, she is a trustee who was under a strict duty to act solely in the interest of the beneficiaries and to manage the trust property prudently. However, her unauthorized withdrawal of 300,000 ringgit from the trust account into her own personal account that already contains 20,000 ringgit of her own funds is a breach of the duty to segregate trust assets. This act of mixing trust and personal funds is expressly prohibited, as this undermines the security of the trust and violates the principle that trustees must not place trust property at risk for personal reasons. Furthermore, Nadira's use of that 100,000 ringgit to purchase the shares in her own name is a direct breach of the no profit rule and the fiduciary obligation to avoid conflict of interest. The rule in Regal Hastings and Gulliver makes clear that even if the trust profited, the trustees are not permitted to benefit personally from trust opportunities. So Nadira's conduct clearly falls within the scope of this prohibition, as she made a personal gain from funds she was duty bound to protect. So similarly, her use of 60,000 ringgit on her kitchen renovation, as well as 50,000 ringgit on a vacation, and the 30,000 ringgit for her daughter's university fees were all for personal or third party benefit, none of which served the purpose of interest of the trust. These actions violate the core duty of loyalty and good faith expected of trustees and constitute willful misapplication of trust property. Most notably, Nadira's withdrawal of 150,000 directly from the trust account to purchase a car which she registered under her own name. This was not merely a procedural error but a knowing and unauthorized use of trust funds for personal enrichment. The purchase of the car using trust funds without the consent of co-trustees or beneficiaries and without any indication that it served the trust purposes reflects a serious disregard for her legal obligations. In addressing Azlan's situation, reference can be made to the case of Ri Haji Ali, whereby in this case there were 3 trustees and one of them a semi-illiterate woman who was found to have acted honestly and reasonably, so the court excused her from liability. However, the other 2 trustees were held jointly responsible for the breach of trust committed by one of them. This case shows that trustees who stay passive and do nothing while another trustee misuses the trust assets are usually not excused from liability. So the essence of this case is that a trustee must be actively involved in managing the trust and cannot avoid their duties unless properly delegated. So to apply in Azlan's case, his frequent travel and lack of involvement show that he was a passive or inactive trustee. Therefore, Azlan's failure to supervise or question Nadira's actions despite being a trustee reflects his role as a passive or inactive trustee. So this lack of involvement, especially if it enabled the breach to occur, may render him liable for the trust losses. Under trust law, being a passive trustee does not excuse liability. Thus, Azlan may still be held accountable for neglecting his joint duty to protect and administer the trust. For Faizal, a trustee is not normally liable for breaches committed by other trustees after his resignation. However, this immunity is subject to an important exception. If the trustee knew or reasonably foresaw that a breach was likely to occur and retired to avoid responsibility or facilitate the breach, he may still be held liable. This principle is well illustrated in the case of Head and Gold, where the court held that liability arises only if it's clearly shown that the retiring trustee contemplated the specific breach that eventually took place at the time of his resignation. Faizal's resignation as a trustee, despite allegedly knowing of Nadira's intention to misuse the trust funds for her personal benefit, may amount to a breach of trust. This is because of the exceptions where the trustees had resigned beforehand due to the knowledge that a breach was likely to occur. His decision to resign rather than raise objections or take steps to prevent Nadira's misuse of trust assets may be seen as a deliberate omission. This failure to act, despite having prior knowledge of the intended wrongdoing, could be construed as passive facilitation of the breach. As such, Faizal may be liable for the loss suffered by the trust as his inaction contributed to the breach committed by his co-trustee, which is Nadira. The Malaysian trust law, the liability of trustees is individual, not vicarious. This means each trustee is liable for their own acts or omissions and cannot automatically be held responsible for the actions of co-trustees unless they were involved in or consented to or failed to prevent the breach. So Section 35, subsection 1 of the Trustees Act provides that a trustee is answerable only for their own willful default and not for the acts of another trustees. However, the duty to administer a trust is a joint duty unless the trustees provide otherwise. So in addressing the liabilities on each trustees, as for Azlan, since he is frequently absent due to his business commitments and during that time he allegedly allowed Nadira to manage the trust informally without proper oversight. However, being absent or delegating duties does not really excuse a trustee from responsibility, since his failure to monitor or question Nadira's actions, his actions may amount to willful default, especially considering the scale of misappropriation involved. So according to the case of Rice and Stokes, where trustees who remained passive while their co-trustees committed breaches were still held liable simply because they failed to step in. Similarly, Azlan's inaction could amount to a breach of his duty to protect the trust property. And as for Faizal, since he had resigned as trustee in June 2024, but his resignation does not automatically remove liability. This is because he had prior knowledge of Nadira's plan to misuse trust funds and chose to resign without taking reasonable steps to prevent it. Therefore, he may still be held accountable for his actions. This is in accordance with the case of Head and Gold, where a trustee who resigns to avoid being involved in a foreseeable breach or who facilitates it through inaction can still be held liable. So, if Faizal knew of Nadira's plan to withdraw funds and failed to act, this could be a clear breach of his duty to act in the interest of the trust. Last but not least is Nadira. She is the primary wrongdoer in this case and is directly liable as the defaulting trustees. However, liability may also extend to Azlan and Faizal, not because trustees are automatically responsible for each other's actions. They are not vicariously liable, but because trustees have a duty to act when they become aware of a potential breach. If either of them knew about Nadira's misconduct and failed to take reasonable steps to prevent it, they may be held jointly liable for the resulting loss. To conclude, Nadira, Azlan and Faizal had committed a breach of liability in administrating the trust.
Assalamualaikum, and I am Rashazina, and I'll be presenting the possible defenses under section 64. But first, we will go through the issue in which whether Nadira, Azlan and Faizal can rely on defenses available on the Trustee Act 1949 to relieve them from liability for breach of trust arising from the misapplication of trust funds.
So there are two defenses that are available for the trustee, which is under Section 63 and Section 64 of the Trustee Act 1949. These defenses are only available if the trustee's conduct satisfies the high equitable standards of honesty, diligence, and loyalty. The beneficiary consent must be informed and unequivocal, and any inaction or passive approval from the beneficiary does not constitute a sufficient consent by the beneficiaries. So first, we will look at Section 63. Section 63 provides defense for trustees that have acted honestly and reasonably. If it appears to the court that a trustee is or may be personally liable for any breach of trust, but they has acted honestly and reasonably, then they ought fairly to be excused for the breach. The court may relieve the trustee wholly or partly from personal liability. The onus or burden of proof is on trustee to prove that they acted honestly, which is without selfish motives, or genuinely believe that their actions would further the interest of the trust. Secondly, they must have acted reasonably, where they must have exercised the level of prudence that is expected from a reasonable person managing their own business affairs. And thirdly, they ought fairly to be excused, where fairly here means to consider both fairness to the trustee and also to the affected person, which is stated in the case of Marsden and Reagan. In the case of Rickey, 1897, it was established that relief from personal liability may be granted either wholly or in part. The court, however, will exercise this power only on exceptional occasions where there is no justification for imposing liability despite the occurrence of a breach, which is also stated in the case of Wilhelms and Byron. This means that the court will only use this power to grant personal liability, to grant relief to the trustee only when there is no reason to make the trustee liable, even though there was a breach by the trustee. In the case of Ong Soo Kok and two others, and Ong Soo Kui 2015, the court said that deciding whether a trustee should be excused is a matter of judicial discretion, which means the court have the discretion to decide whether a trustee can be exempt from liability or not based on the facts of the case. The Malaysian court also treated Section 63 of the Trustee Act as having the same meaning or in pari materia with Section 61 of the English Trustee Act 1925. In another case of Re Haji Ali bin Haji Mohammed Noor disease 1993, the court considered whether a co-trustee could be excused under Section 60 of the Trustees Ordinance 1929. It was held that the trustee bears the burden to prove three things, which we have looked at before. That first, she acted honestly; second, acted reasonably; and thirdly, they ought fairly to be excused. The court must be satisfied on these points, and each case depends on its own facts. There is no fixed subjective or objective test applies. The decision is based on the court's judicial discretion under the section.
Now moving on to Section 64, which is consent of beneficiaries to juries. A trustee can raise a defense if the beneficiary consented to or concurred with the breach. To be valid, the beneficiary must be full of age, sound mind, have full knowledge of the relevant facts, and to be able to exercise independent judgment. Section 64, subsection 1 stated that if the trustee commits a breach of trust at the instigation or request or with the consent in writing of a beneficiary, the court may, if it sees fit, impound all or part of the beneficiary's interest in the trust as state indemnity to the trust. So there are 5 cases that we can refer to under Section 64. The first one would be in the case of Ramasamy anak lelaki Kamachi and others, and Tayalan anak lelaki SK Salanianadi and 63 others. This case applied the court's discrimination power under Section 64. The court may require a beneficiary to indemnify a trustee if the breach was committed with the beneficiary's written consent and at the beneficiary's request. In the case of Re Somerset, the court will only exercise discretion if the beneficiary knew and understood all relevant facts leading to the breach. The third one would be the case of Life Association of Scotland and Siddle, where the effect of beneficiary's participation of or consent if a beneficiary participates in or consents to the breach. They are barred from suing the trustee for that breach. So the next case will be Fletcher and Cullis. If a beneficiary is involved in the trustee breach and this involvement is proven, the beneficiary cannot deny it. Any action by that beneficiary against the trustee will be barred, regardless of whether the beneficiaries benefited from the breach or not. Next, in the case of Stafford and Stafford, a beneficiary may also be prevented from taking action against a trustee based on the beneficiary's conduct after the breach. If the beneficiary shows acquiescence to the breach after it occurs, this may be enough to protect the trustee from future claims by that beneficiary. When there are multiple beneficiaries, the consent of one does not represent the consent of all. Therefore, a beneficiary who did not consent to a breach of trust may still bring an action against the trustee, even if another beneficiary agreed to the breach. Under Section 64, the court has the discretion to excuse a trustee from liability for a breach of trust if it is satisfied that the trustee acted honestly, reasonably, and ought fairly to be excused. The burden of proving all three elements lies on the trustee.
In Section 63, we will first look at one of the parties, which is Nadira. Nadira cannot rely on Section 63 as a defense because her conduct was dishonest and unreasonable. She misappropriated 300,000 ringgit from the trust into her personal account, as she enriched herself at the expense of the trust, mixed it with her personal funds, and even used it for personal expenses. Her act was also intentional, amounting to deliberate violations of her fiduciary duty as a trustee. Section 63 does not apply given the absence of both honesty and prudence in her conduct. Therefore, Section 63 cannot be used to protect Nadira from liability. Next, we will apply Section 63 to Azlan. Azlan may attempt to argue on Section 63 by claiming that he acted in good faith and was unaware of Nadira's misconduct. However, Azlan has a continuing duty to stay involved and supervise the administration of the trust. His absence and lack of engagement by frequently being abroad and allowing Nadira to handle everything without proper supervision or formal delegation may be suggested by the court as a serious neglect of duty. He is said to have informally allowed Nadira to manage the trust. While he may not have directly participated in the misappropriation by Nadira, his failure to stay informed and exercise control may amount to negligence. However, he did not monitor or supervise, which can cause a potential negligence where he is not directly involved in the misuse. Hence, Section 63 cannot be used to protect Azlan from liability. Next, we will look at Section 63 to apply on Faizal. Faizal also cannot rely on Section 63 for protection because his failure to act on known risks which cannot be considered honest and reasonable conduct. This is a duty of what is expected from a responsible trustee. Although he did not personally misappropriate any trust funds, he was allegedly aware of Nadira's plans to misuse trust funds. Instead of intervening or informing the beneficiaries, he chose to resign rather than raise concerns or report the matter to the beneficiaries. His failure to investigate or alert the others despite foreseeing potential harm is not the standard of care expected of a reasonable trustee. Regardless of whether he believed he was avoiding conflict, his decision not to act when action was needed cannot be seen as reasonable or honest in the eyes of the court. Therefore, Section 63 also cannot be used to protect Faizal from liability.
Now, by applying Section 64 in the present case, there is no proof that any of the beneficiaries formally agreed in written consent or gave a clear approval. While Faris and Nadia were similarly aware of what Nadira was doing and opted not to intervene, their lack of response and silence amounts to mere passive acquiescence. This kind of inaction, without clear proof that they fully understood and agreed to what was happening, does not meet the legal threshold of informed consent under Section 64. As a result, this section cannot be relied on as a valid defense against Alia's claim. So, let's take a look at Nadira's situation. Nadira, an active trustee, misappropriated Rm 300,000 from the trust of her own benefit. She spent the money on personal purposes like upgrading her house, going on an expensive holiday, buying a vehicle, paying her daughter's university fees, and making investment under her own name. Her actions were intentional and dishonest, representing a major breach of fiduciary duty as a trustee. While Faris and Zara were aware of what she had done and chose not to respond and remain silent. Alia only became aware in January 2025 after all of these events had taken place and did not give her approval. Therefore, Section 64 cannot be used to protect Nadira from liability. Now, moving on to Azlan's situation, in which he was formally appointed as a trustee, but he was mostly absent and left the management of the trust in Nadira's hand without proper oversight and allowed it informally. There is no evidence that he was actively participating or aware of the misuse of misappropriation, but his failure to monitor or intervene breaches his duty to act jointly and prudently. Since Alia had no knowledge of the breach, Section 64 cannot be relied upon his defense. Now, in Faizal's situation, he resigned from his role as a trustee in June 2024, but it is alleged that he was aware of Nadira's plan and intention in misusing the trust funds. Instead of addressing the concerns or acting to prevent a breach, he chose to resign silently. This passive response falls short of the standard expected conduct of trustee. Given that Alia was unaware and did not agree to the breach, Section 64 offers no protection for Faizal either. So now, in Azlan and Faizal's situation, they may argue that they did not directly participate in any breaches and acted honestly. However, Section 64 is not concerned with protecting trustee based on honesty or involvement in the misappropriation. This section focuses entirely on the consent to the breach by the beneficiary. Since Alia did not consent nor was aware of the misconduct, they cannot rely on Section 64 to avoid liability to her claim. Meanwhile, in Faris and Zara's situation, their inaction may prevent them from suing in the future due to acquiescence. However, this does not affect Alia's right to bring a claim. Her lack of knowledge and non-involvement means Section 64 cannot protect the trustee from her claim. For Faris and Zara, it depends on whether fully informed consent can be proven. Therefore, Nadira, Azlan, and Faizal cannot invoke Section 64 as a defense against her. Thus, Nadira cannot rely on Section 64 since her conduct lacked honesty, prudence, and any justification. Azlan might be eligible for partial relief under Section 64, but his prolonged unsupervised makes it unlikely for the court to excuse him entirely. For Faizal, Section 64 is also unlikely to apply as his awareness of the impending misuse and failure to intervene does not meet the standard of reasonable behavior expected as a trustee. In conclusion, Nadira, Azlan, or Faizal cannot successfully raise defense under Section 63 and Section 64 of the Trustee Act 1949.
The next issue is whether Alia could recover the trust property or its value from Nadira. To begin with the law part, we begin with the question of what is the equitable remedy of tracing? The right to follow the trust property allows a beneficiary to follow trust property when it has been wrongfully disposed of or converted. The aim is to recover the asset or its substitute. There are three rules applied in order to apply the principle in hand. The first one is there must be an initial fiduciary relationship. The second one is the trust property must still be in a traceable form. The third one is the tracing of property must not lead to an inequitable result. For the first rule, which is the initial fiduciary relationship, it must firstly be established that there is the existence of such relationship, which may arise from either a constructive trust or an express trust. We apply two cases in this situation. The first one is the case of Rehallet's estate. The issue of tracing does not arise in the absence of an established trust. However, tracing is only accessible as a remedy after the establishment of a trust. In the case of Sinclair against Broham, tracing is actionable against the third party without the necessity to create a fiduciary relationship with the beneficiary if possession of the trust property has shifted from the trustee to a third party. In applying this principle, applying the first case, which was the Rehallet's estate, tracing can be constituted as a remedy since there is a trust for the benefit of the beneficiaries, which were Alia, Faris, and Zara. And applying the second case, the case of Sinclair against Broham, tracing is actionable against Nadira's daughter and the local NGO as third parties, to whom an amount of money has been transferred. Applying the second rule, traceable form of trust property. If trust money had been used to purchase a property, there are two separate situations. The first one is mixed fund, and the second one is unmixed fund. For the situation of mixed fund, the beneficiary would be unable to choose to take or repossess the property because it was not purchased primarily using trust funds, which was applied in the case of Hallett's estate. The beneficiary will only be permitted to hold a charge over the property purchased with money from the mixed fund for the amount of trust money specified in the acquisition. For the case of unmixed fund, the beneficiaries would have two options: either take the property purchased or place a charge on the property for the amount of trust money used from the fund. In the case of Re Deplock 1948, it was established that the equitable remedy of tracing is only available to the beneficiary if there is still trust property to trace, even if it is no longer in its original state. However, if the property has been consumed or dissipated, it is no longer traceable. In order to apply the case of Re Deplock, the equitable remedy of tracing is available to Alia when there are properties to trace, such as the trust money of RM300,000 transferred to Nadira's account, whereby the amount of money used to buy shares in her name and the car registered under her name. The rest of the money that had been consumed for her home kitchen renovation, a luxurious vacation in Europe, her daughter's private university cost payment, and a donation to the local NGO are no longer considered to be traceable. Nadira had a mixed sum of RM300,000 from the trust account with her account, which already had 20,000 ringgit of her own funds. However, as per Rehallet's estate, Alia can still have a charge over the property purchased by the use of money from the mixed fund, like the value of the shares bought. On the other hand, since the purchase of the car registered under her name came from an unmixed fund, namely the trust fund itself, Alia is entitled to either take the car bought or have a charge over the car for the amount of the trust money used from the said fund. In a specific situation where trust money was used to make a purchase of property that has resulted in a profit gain, if the trustee made the purchase, he is not entitled to any profit earned or credited on the property purchased with trust funds, whether it originated from a mixed or unmixed fund. If the purchase was made by a third party, with money from an unmixed fund, he is entitled to keep any profits made. In the case, we can see that since the purchase of the shares was made by Nadira herself as a trustee, she will not be entitled to keep any profit that was gained or made on the shares bought, which was as much as 35,000 ringgit, regardless of whether it came from a mixed or unmixed fund. Regarding the third rule, which is tracing of property must not lead to an inequitable result, if granting the beneficiary the right to trace would lead to an inequitable result, the court will not grant the said equitable remedy. As a result, if a third party made a bona fide transaction using trust property, granting the beneficiary the remedy of tracing would be inequitable. According to the case of Re Deplock again, it is unfair to force an innocent volunteer to sell land they purchased with trust funds and registered in their name. However, if the trustee gave the innocent volunteer money, which is the trust money, to buy land that will be registered in the trustee's name, tracing should be allowed and granted to the beneficiary. Applying to the current case, since both the purchase of shares and the car were under Nadira's name, not bought by a third party or bona fide purchaser, a grant to Alia her right as the beneficiary to trace would not lead to an inequitable result. In conclusion, Alia will be able to recover the trust property or its value from Nadira through the equitable remedy of tracing.